Hello friends. Today we're going to discuss about medical negligence in doctors in training. That means if there is a medical negligence occurring by a MBBS student or else MD or MS student, that is postgraduate students, what will be the liability? That will be discussed in this video. I'm Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. As I mentioned, I'll be discussing about medical negligence, which occurs by a undergraduate medical student, that is MBBS student, or else by a postgraduate student. Either it can be MD, MS, DNB, or maybe even super specializing student. What are the medical liabilities when they are providing services? If there is a medical negligence, what will be the liability from criminal negligence versus civil negligence, and how the vicarious liability is applicable in doctors in training, and I'll be giving conclusions and my recommendations. Let's discuss an important case law, that is Liability law from New York. Liability is an 18-year-old female student. She was studying in New York. One fine day, around 11 p.m. in the night, she reported to the emergency room of the hospital. She had fever, jerking movements, and restlessness. She was oriented. She reported that she was taking antidepressant phenelzine, that is, monoamino oxidase inhibitor, on daily basis. She also discussed about her problems with regard to restlessness. Immediately, there were two junior residents in the hospital who assessed her and admitted to the ward. She was briefly evaluated by both the junior residents, and one of them was a first year and the other was a third year junior resident. They also discussed with the family physician, and finally the decision was given to give pethidine, that is meperidine, to calm her down. So the pethidine was given to Libizion immediately, and both the doctors went back to the casualty. After some time, she became restless, and again the duty doctors were called. They examined her again and gave injection haloperidol. Further, there was increase in fever and restlessness worsened. Hence, a physical restraint was ordered. At the same time, they continued hydration. Unfortunately, by early morning, she expired. Libby Zion's father, Sidney Zion, was a lawyer and also a journalist at the New York Times. He became angry and took the hospital, the junior residents who were on duty, and also the family physician. Since he was a journalist, he wrote in his column, he mentioned, "You don't need a kindergarten to know that a resident working a 36-hour shift and being in charge of 40 patients that night is in no condition to make any kind of judgment call. Forget about life and death." He clearly mentioned how the junior residents were in charge of 40 patients and they were given in charge of looking after Libizion, and they made some mistakes due to which she died. Not only that, the Zednizion, the father, argued that there was inadequate staffing in the teaching hospital and long working hours, that is 36 hours, was inhuman. Further, he also argued administration of pethidine for a patient who is taking phenelzine, that is monoamino oxidase, was fatal, which caused selective serotonin reuptake inhibitor syndrome, that is SSRI syndrome, also called as serotonin syndrome. I have made a separate video. You can go through my YouTube channel to know about SSRI syndrome. He took them to the court and asked to press criminal charges on the doctors. The court denied to press criminal charges, and further, the civil negligence case was taken, and the father also urged the junior residents and the family physicians licensed to practice to be cancelled. But however, the court refused to accept that. But in the civil negligence case, a Manhattan jury found that the two residents and the Libizion's primary care doctor contributed to her death by prescribing the wrong drug and ordered them to pay $375,000 to Zion's family for her pain and suffering. At the same time, the jury also ordered a Bell's Commission, a committee on emergency services, recommended that attending or a qualified physician should be present at all time in the emergency services, and also ordered the hospitals to limit the residents' duty 80 hours per week and not more than 24 hours a duty time. This was the landmark judgment which was given with regard to the residents who were undergoing training. That means a doctors in training were sued under the law. That means the students are not immune for medical negligence. With this, let's discuss about what is happening with regard to medical doctors, especially the students, how the medical liability is taken. In this contemporary world, the incidence of medical malpractice is increasing day by day. And this is a serious concern not only to the doctors, but also to the MBBS students, postgraduate students such as doing MD, MS, DM, and it is increasing the fear in all these students. Residency program, that is this training of these doctors, is vital component in the education and training of this physician so that they become independent and address the public health issue. If you look at the number of UG doctors, that is undergraduate doctors who are undergoing training, is up to almost 1 lakh. Further, there are other paramedical staffs like nursing, radiographers, allied healthcare professionals, graduates, postgraduate students like doing MD, MS, DNB, diploma, and also super specialization. Further, the government of India has decided to open one medical college in every district. We have more than 600 medical colleges at this point of time. Further, the new National Medical Commission Act 2019 has given permission to start post-graduation in any corporate hospitals. That means the number of students, either undergraduate and postgraduates, will be providing services in these teaching institutions. Added to this, the Consumer Protection Act of 2019 has increased the pecuniary jurisdiction for the complaint. At the district level, the patient can give complaint up to 50 lakhs rupees. He can approach state commission if the compensation is between somewhere around 50 lakhs to 2 crore rupees. That means this new law, the Consumer Protection Act, and increasing litigation has become a serious concern for the undergraduate, postgraduate medical doctors. This medical negligence, malpractice cases is one of the way to protect the patient also. If you look at the prevalence of malpractice or medical negligence case in undergraduate or postgraduate students in US is less than 1%. That means 1% claim has been settled in US where a undergraduate or a postgraduate student has been named in the case. However, certain states talks about the case filed. It's not the settlement of claim. The case filed is between somewhere around 12 to 22%. However, the patient may win is less than 1%. With regard to data from India, it is not available. Now the question we need to answer in this video is, can an MBBS student sued for medical negligence? Can an intern, when he is doing compulsory rotating medical internship, can be sued for medical negligence? Remember, both the MBBS students and the compulsory rotating medical internship, that is house surgeon, they are not yet been licensed to practice. Can they be sued? Legally, they are not doctor at all. However, with regard to PG students, that means they are already licensed to practice. Their name has been enrolled in the State Medical Council and also the National Medical Council. If there something goes wrong when they are doing post-graduation, can they be sued for medical negligence? That will be answered in this video. Now let's understand how the medical negligence is assessed in India. To establish medical negligence, certain important essential ingredients need to be proved by the patient and their party. There are 4 important ingredients. The first one is there should be a duty of care. Second one is that duty of care should be breached. That is, there should be an act of commission or an omission. That is, failing to provide a reasonable degree of care. That is, standard of care is not given by the doctor. Because of this breach of duty, there is a damage. And the damage is directly related to the breach of duty. These 4 needs to be established in the court of law. Then only the medical negligence will be established. The medical professional is expected to bring a reasonable degree of skill and knowledge and must exercise reasonable degree of care. The court in India is very clear and categorical. They do not expect very high standard or else very low standard of care and competency to judge the doctor for medical negligence. That means the law is very clear in India. That means it does not expect very high degree of care or else very low degree of care. It is talking about a reasonable degree of care to be provided to the patient. In this regard, to assess the standard of care, the Bolam test comes into picture. I've made a separate video with regard to Bolam test. You can visit my YouTube channel and find the video on Bolam test. This was a case which is Fraternary Management Hospital versus Bolam. This was decided in 1957. It was decided by a Judge McNair, who stated that in his judgment, a doctor is not guilty of negligence if he or she acted in accordance with the practice accepted as proper by a reasonable, responsible body of doctors skilled in the relevant field of practice. That means if the doctor is able to follow the standard of care which is approved by the responsible body of doctors, that means if there are 2-3 different practices, if he's able to follow one of them, then he is not negligent. But the question arises is, what is the standard of care for a postgraduate student? For a medical student who is doing undergraduation? What will be the standard which has to be assessed for a first year MBBS student versus final year MBBS student, or else first year MD student versus third year MD students versus a chronic repeater versus a super specialist student? What should be the standard of care? That's a big question we need to answer. A medical practitioner would be liable only where his conduct fell below the standard of reasonable competent practitioner in his field. That means a reasonable practitioner means if he is doing MD in medicine, that means he should be considered as a MD student and his standard should be equate to the other MD student, or else below that should be like MBBS graduate versus a specialist. There are certain important judgment in US and UK. They talked about if there is a simple plaintiff should prove more likely than not standard by the patient, then the medical negligence can be proved. That means if there is a high possibility the negligence would have occurred because of act of omission or commission, then the medical negligence can be considered. The standard of care in medical practice litigation is critical to determine whether the compensation should be given or the doctor should be punished under the criminal law. Identifying the standard of care applies to a resident is an important question to be answered. That means he should be assessed with a qualified doctor, or else a qualified specialist, or else a qualified super specialist, or else should we assess a student if he's a first year, should we assess with the next first year student, or else if a second year student, if there is something goes wrong, should we consider to assess with the next second year student, or else based on the curriculum of the PG should we assess is the big question. The liability only occurs if either doctor did not possess the requisite skill which he professed to have possessed. That means if a doctor says, I have done MD medicine or MS surgery, and he does not have the requisite degree, then it will be considered as negligence. Or else he did not possess or exercise the reasonable competence in a given case, the skill which he did possess. That means he had the degree and he possessed the skill, but he did not bring that skill to the table. That means there are two important criteria. If it does not have the degree, the required degree, then it will be considered as negligence, or else he has a degree, but he did not bring the skill to the table. But again, the question comes here, the student, either MBBS or the postgraduate students, they are not qualified yet either to become a general practitioner or a specialist. Then, just because there is a medical negligence and they don't have a degree, should we punish is a question. Now let's look at the various factors involved in breach of duty from the doctors in training. With regard to MBBS students and house surgeons, they are not yet registered medical practitioner. They have not got the license to practice. However, in India, they are allowed to practice. If there is any untoward incident occurs, can the patient family can go to the court and ask they are not registered, why they are practicing? Can they be punished? Next, the question is, if a MD, MS or a PG student or a super specialty students, they are qualified as a general practitioner, how to be assessed? What should be the yardstick to say what is the reasonable degree of care or the standard of care? Here, a breach can occur by doing active harm to the patient. That means the PG student or the undergraduate student may do something to the patient and there may be an injury or he may die. Or else the PG or UG has to do something to protect the life of the patient, but he does not do anything. That is failure to diagnose or failure to treat can also be considered as a medical negligence. Further, a doctor's in training, that means a PG student, can also do moonlighting in the evening. That means after the working hours, he may go in the evening and do private practice, or else telemedicine practice, or he may go to a nursing home and do practice. What will be the liability in such cases? One, the liability in the training institute or the liability during telemedicine practice. What about the liability if he's doing a independent practice in the evening in a corporate hospital in mind? Now let's look into the factors involved from the supervisor side, that is, from the specialists who are hired in these teaching institutions. The supervisors, that is, teaching medical faculty in the medical colleges or else in the hospitals where they are running DNB courses. The liability can be from three distinct domains. These potential liabilities, either it can be direct liability. The specialist not only has to train the students, but also is providing care. There can be a direct liability of medical negligence or else vicarious liability, where the students who is supposed to supervised by this supervisor does something and the medical negligence can come on the supervisor, that is vicarious liability. Further, the students are not at all supervised, that is failure to supervise. These are the three important liabilities can come on the supervisors, that is teaching medical faculty in the medical colleges or in the teaching corporate hospitals. Further, we all know there are ghost faculties. It is a well-known phenomena in the Indian medical colleges. Our own doctors sell their degree for 10,000 or 20,000 and they do private practices and they do not even train even a single student. We talk about highly about medical education, but our own fraternity sell their degree to medical colleges. We need to think about this. And many a time the students who do not get supervised, what kind of doctors they are going to become tomorrow? Many a time supervisors are known to do multiple practices. They would have given their name in various nursing homes, polyclinics. They come to the hospital in the morning at 8 o'clock. They do punch in. They put the attendance register, and by 10 a.m., they are outside doing private practice. Without supervising the students, what will the students learn? This is the biggest problem in our medical education. Further, faculties in the hospitals who are doing DNB training, they are more worried about their income rather than training the students. This itself also causes a big problem. How does these DNB students learn? They have to learn by just watching. Many a time, these doctors who are working there as a specialist may not show any interest in teaching them. Further, the supervisors also will say, we are just a on-call duty. Whenever there is a problem, they will give a call and I will suggest the duty doctor what to do on the phone. Hence, I can't be held responsible. Further, any area of particular uncertainty involves what is the appropriate supervision by a on-call duty doctor. What is that appropriate supervisory role is not been fixed at, and it is very difficult to fix. Imagine if there is a emergency call from a casualty and the doctor is at home. That is a specialist who is supposed to train the doctors who are in the emergency. And if he guides the students in the emergency what to do, how much should be the guidance? What is the supervisory role? What is that appropriate guidance? Is it audio call? There should be a video call, or should they be physically present? These are the issues which needs to be discussed. Now let's look into the factors involved in breach of duty from the medical colleges or by the training hospitals. These training institutions or the medical colleges, they have poor infrastructures, poor facilities, lack of human resources. They do not have adequate supervisors. On paper, they are there. They are all ghost faculties. Many a time, these hospitals may hire incompetent supervisors because of political pressure, bribe, and various reasons. Both, it's not only in the private medical college, even in the government medical college. Many a time, they are hired on contract basis or else pay per consultation basis. If that is the scenario, how they will teach the student? And these institutions allow the doctors to do moonlighting so that they can cut the cost, telling that you are allowed to do private practice, but we will pay this much only. All these institutions will do various things to cut the cross. That is, cutting cost is their main aim and maximize the profit. Further, many a time these medical colleges may take more students for donation purpose, for management seat. Although they have been given less number of seats by the National Medical Commission, they would like to take more students and challenge the NMC in the court of law. By the time, as you know, our courts, they take sweet time, a decade, to decide these cases. By that time, many students would have passed without any supervision. And these institutions entertain ghost faculty. There is no periodic training of these supervising faculties, and there is no regular audit. Many a time these hospitals do hire non-allopathic doctors to train allopathic students, untrained professionals, untrained allied healthcare professionals. There is no proper handover of cases from one shift to another shift, especially in the casualty. This lack of communication, no training in skills, and many a time the shift from one shift to another shift is the time where maximum medical negligence occurs by the medical students. There are many other factors which also contribute for the breach. Was this an emergency operation or a procedure, or is it an elective? If it is an emergency, if the supervisor is not available, can the PG do these operative procedures? We have to save the life of the patient. It is ethics over law. Which one should we follow? If we follow the rules and laws, unless the supervisor comes, you are not supposed to do anything. Further, many a time the trainee may not discuss with the supervisor. He may take independent decision. Who will be held responsible? Fatigue of the trainee, fatigue of the supervisors. Many a time there may be 10 supervisors. There may be one or two supervisors who are interested in teaching. They will be teaching many students. Poor communication between the student and the supervisor. Other trainees from nursing, from paramedical staff, allied healthcare trainees also may contribute to medical negligence. Further, from the patient side, last minute consultation, violence, intimidation from the family members of the patients, finance related issues. The doctor would have given order for treatment. Because of the non-payment, the treatment is withheld by the hospital administration or by the medical college. Delay in the approval of insurance companies can also contribute to medical negligence. Non-availability of operators, technical snags, or the operators are available but they are malfunctioning. There is no maintenance of these instruments. Further, human body is very complex. It's very difficult to say who will be surviving and who will die. Now the question is, with all these various factors, from the graduate, from the supervisor, from the hospital, to the other factors, how do we fix the liability on these training students? There are three important types of fixing liability. One is criminal medical negligence, second one is civil medical negligence, and the third one is disciplinary action, that is, erasure of the license to practice. That means the state medical council or the national medical council may give an order to remove their name from the registry. Now let's discuss about criminal medical negligence, both under Indian Penal Code and the current Bharat Nyaya Samhita, which clearly talks about medical negligence and punishment. In the new Bharati Nyaya Samhita Act of 2023, no doctors have been given any exemption. They are punished similar to Indian Penal Code 304A, 336, 337, and 338. Corresponding section under Bharati Nyaya Samhita 2023 clearly talks about for death because of rash and negligent act, punishment is 2 years with fine. For endangering life by a doctor, it's a rash and negligent act, 3 months imprisonment or 2,500 rupees fine or both. With regard to simple injury, Section 125A of BNS clearly talks about 6 months imprisonment or 5,000 rupees or both. With regard to grievous injury, because of rash and negligent act of a doctor, the imprisonment is 3 years or 10,000 rupees fine or both. That means, my dear friends, the newer Bharatiya Nyaya Samhita has not given any exemption to doctor. Both under Indian Penal Code and Bharatiya Nyaya Samhita, it is very clear. An act to be a criminal negligence for a doctor, the prosecutor must prove the doctor has acted in a gross negligent way. That means it's just not a negligent, it should be gross, and has created a high risk of death or a bodily injury. Further, a prudent doctor had known the consequences of the act would have not done this. These are the elements which has to be proved in the court of law. This has been clearly done by the Supreme Court of India in Suresh Gupta versus Government of NCT in 2004, and also another landmark judgment, Jacob Matthew versus State of Punjab in 2005. In Suresh Gupta's case, the apex courts clearly said that doctors would be unable to save life if they were able to be trembling with fear of facing criminal negligence case, and they will be punished. No doctors will take any risk. If the patient has a 50% chances of surviving, no doctor will operate or treat him, because there is a 50% chances he will be dragged to the court and he will be imprisoned for rash and negligent death. That means we need to protect the doctor. Hence, the Supreme Court was very clear in both Suresh Gupta's case and Jacob Matthew case. Further, in Jacob Matthew's case, the Supreme Court went ahead and recognized that doctor have the task. Sometimes he has to take a risk of higher degree to protect the life of a patient. If even there is a chance of 10% by doing an intervention of survival, and if you don't do any intervention, there is a 100% chance he's going to die. By taking a risk of 10% survival rate, the doctor would do some surgery or a life-saving procedures. In such a scenario, we need to protect the doctor. Hence, the Supreme Court in Jacob Matthew case clearly said that private complaint should not be entertained against the doctor because death is due to negligence. Before a FIR is filed, an opinion should be sought by the investigating officer from a medical expert, preferably from the government. Once, if the medical expert says that yes, there is a medical negligence, then only FIR has to be filed. In this regard, what will be the role if the medical negligence caused by a MBBS student or by a PG student? It is very clear if you look at all the Indian Penal Code or else by the BNS. It is the person who is acting upon. That means unlikely the supervisor will be pulled in. It is the student will be responsible for criminal medical negligence. Hence, It is a direct liability on the student. Hence, the student should make sure before they do any procedure, there should be supervisor available next to them. Hence, do not do any procedure without informing the supervisor. Before you do any procedure, please take permission from your faculty. Wait for the supervisor's instruction. Vicarious liability invariably is not applied in criminal negligence. Vicarious liability is applicable in civil negligence. Hence, these trainees will be held directly responsible for criminal medical negligence. Now let's move into civil medical negligence. It is a common sense that when a patient goes to a hospital or a medical college, he believes that this hospital has a good reputation, this college has a good reputation, there are good faculties who provide care, with the hope that a due proper care will be given in this medical hospital or in the teaching institution. They go to this hospital for treatment. If this hospital or this medical college has failed to discharge the duties through their doctors, maybe even a trainee, or maybe even a paramedical staff who are trainees, who may be employed, who may be on ad hoc basis, who may be even part-time, and if they do not monitor them through a supervisor, then this hospital and the supervisor will be vicariously liable for medical negligence under civil cases. Now let's understand what is this vicarious liability. Usually, whenever a person commits an act which is unlawful, that person will be held responsible. Whereas in vicarious liability, the general rule is in some situations, person can be made liable even if he has not done any wrong. If it is done by somebody else, that is vicarious liability. Vicarious liability is a principle that holds one party responsible for the action of another party. That is, invariably, if a driver is hired by a owner for a salary, and if the driver makes an accident, invariably, under the civil negligence, the owner will be sued. That means employer-employee relationship is there. Then vicarious liability will comes into picture. That is classical under the civil law or tort law, not in the criminal law. The vicarious liability clearly says, under the Latin legal maxima, qui facet per alium facet per se, means he who does an act through another is deemed in law to be have done it himself, or liability by relation. Vicarious liability means the liability of a person for an act committed by another person, and such liability arises due to the nature of relationship between the two. That is classically master-servant relationship, that is employer-employees relationship. Here the master employs the service of the servant and works on the command of the master, and thus a special relationship exists between the two. And in case of a tort or a civil law, here master will be held liable for compensation, not the servant. Again, the vicarious liability is liability based on two important maximas. As I mentioned, Q facet per alium facet per se, or respondent superior need to answer. Now let's look into Q facet per alium facet per se. It means that whenever a person gets something done by another person, then the person is viewed to be doing such act himself. For example, as I mentioned, A is a driver who works under B. While driving B's car, A makes a mistake. There is an accident. In such a scenario, the owner A will be sued under civil negligence. Considering the second maxima, respondeat superior, let the master answer, is the legal principle that holds an employer liable for the negligence of its employees in certain circumstances. It means that the superior should be held responsible for the act done by the subordinate. In simple, in a medical college or a hospital, if the case is supposed to be seen by a senior specialist, but the senior specialist delegates to the junior most person, that may be a trainee. And if there is a negligence done by this trainee, the senior has to answer. That means let the master answer. That is, respondeat superior shall be held responsible. That is vicarious liability. It is well established that a hospital is also vicarious liability for the act of negligence committed by the doctors engaged or employees or empaneled doctors to provide medical care under the hospital. This is well established in various Supreme Court judgments and also High Court judgment. It is a common experience that when a patient goes to the hospital in the name of the hospital, not thinking that a postgraduate student or undergraduate student will treat them. In such a scenario, if the medical college or the hospital where these trainees are there, if they fail to make sure that the supervisor is not there during the treatment, then the hospital also will be held responsible for the negligent act of the supervisor for not supervising, and also for the act of their students. Please remember, this vicarious liability is for only civil cases, not for the criminal cases. Hence, the liability can be corporate liability or else the liability for not supervising the students. Hence, the grant of compensation given to the patient will be drawn from the hospital, from the supervisors, and it can be from the students also. It is based on the principle of restitutio in integrum. That means somebody has to pay for the pain and suffering because of the medical negligence. The negligence can arise from the students, can be from the postgraduates, or the supervisor not supervising them, and the medical institutions not monitoring the supervisors. What are the common defense used by the hospitals and the medical colleges? These hospital and the medical colleges can argue the vicarious liability is not applicable to them. The reason being, the person who is negligent is a student. How can we hold the student responsible? These students are sent by the government through a NEET exam. The supervisor is an independent consultant. How can we dictate these senior consultants? And these senior consultants are not coming in time. How can we tell them? He's a trainee. A trainee, how can we monitor them? He's a house surgeon. How can we make them responsible? Many times the hospital also may say, he's a locum doctor. He's on contract basis. He's an ad hoc. We pay per consultation. Hence, he is not our employee. Hence, employer-employee relationship does not exist. Hence, vicarious liability does not exist. These are the common defense used. Further, hospital may also argue that the doctor was not working in the defined hours. He was not there to supervise the student. Hence, the hospital will completely disown the patient's compensation. Or else they may say, the trainee exceeded the scope of employment. He is not a salaried person. We are paying per consultation. Further, they may also say the facility was hired for the patient. Such common defenses should be countered carefully, and we need to analyze based upon the case-by-case basis. Further, these training medical colleges invariably file their affidavit telling that we have these many supervisors. That means they are responsible to make sure these supervisors are available because they are paying salary to them. They may call whatever their name, telling that it is a part time, this is honorary, but these medical colleges and hospitals will be held responsible. Many a time, they also declare the number of PGs they are hired is based upon the number of supervisors are available. And these medical colleges allow ghost faculties. That means they have to be held responsible. Many a time, these private medical colleges and government medical colleges allow private practices. And these private practices make these supervisors to leave the campus early. And hence, we need to analyze the case by case basis how this civil negligence should be brought in. What was the employment agreement has to be seen. In this regard, the National Consumer Forum has given a landmark judgment in Srimati Rekha Gupta versus Bombay Hospital. In this case, National Consumer decision was categorical and clear. Any hospital, they cannot escape its liability by merely saying that we cannot monitor the consultant, the supervisors, we cannot do any operations by ourselves. He is the one who is in charge, he is a professional. We have just provided the infrastructure facilities. We are provided just a nursing services, support staff, technicians, equipments, medicine, and place. Such kind of excuse is not allowed as per the National Consumer Forum. Further, it also said the hospital is not only responsible for the staff it provides, but also responsible for the contractors. That means the hospital may subcontract certain activity. It can be laundry, it can be housekeeping, it can be security guards. That means these hospitals will be responsible not only for hiring the doctors directly through employer and employees relationship, but also through contract, that is subcontract. It can be called as contract for services and contract of services. Both the hospital will be held liable for compensation under civil law. That means, my dear friends, the courts in India is very clear. Under civil cases, both contract for services and contract of services are brought under the ambit. Hence, these medical institutions, teaching institutions, teaching hospitals will be held responsible under civil law. Invariably, these students and trainees may not come under the ambit of contract for services or contract of services. Since these hospitals file their affidavit that we have so many supervisors to look after these students, hence these hospitals and supervisors will be held responsible under the civil law. But however, under criminal law, the students will be held responsible. The UGs, interns, and the PGs are meant to be trained in these hospitals, not generating revenue either in the name of donation or else making them to work as a slave. These students need to be trained under the supervisors, under National Medical Commissions Act and their regulations. Hence, all these medical colleges and teaching hospitals are advised to ensure that they have agreement in place, not only for the supervisors, but also to the trainees, postgraduate students. What is the standard operating procedures? When to take help? Under the supervision, they are supposed to do certain acts, and they have to be barred by doing any independent act or operations or procedures without the supervisors. Hence, proper supervision is mandated as per the NMC Act, and the same thing will come under the law when there is any medical negligence by the trainees. Thank you very much for your valuable time. Stay safe.